Hi there everyone, and welcome to Alliance Live. It's a new online information and learning portal showcasing examples of innovative and integrated working taking place across Scotland within health and social care. We continue the series of these 30-minute webinars focusing on incorporating the UN Convention on the Rights of the Child into Scots Law. Our guest today is Juliet Harris, Director of Together, Scottish Alliance for Children's Rights. Juliet leads the organisation in promoting and monitoring the implementation of Scotland's international human rights obligations to children and young people, including the UN Convention on the Rights of the Child, UNCRC. She works with Together's membership of over 380 children's organisations and professionals to produce an annual State of Children's Rights report, liaises with government and parliamentarians to further children's rights in policy and practice, and reports on progress to the United Nations Committee on the Rights of the Child. Finally, as the panellists deliver their presentations, we invite the audience to pose questions using the chat box, which you can find at the bottom of the toolbar, which can be found around about the bottom of the screen of the Zoom window. These will make up the questions for the Q&A session, which will follow on from the presentation and bring our webinar to a close. So without further delay, I'm going to pass it over to Juliet.
Thank you. And in the next 20 minutes or so, I'm going to go through the consultation on incorporating the UN Convention on the Rights of the Child into Scots law. And I want to look at, first of all, what is incorporation, and then explore some of the background as to how we've got here. How have we got to the point that the Scottish Government is consulting on incorporating the UNCRC into law? I want to talk through a draft Children's Rights Scotland bill that a panel of experts has drafted for Together and the Children's Commission of the which sets out how a model of incorporation could look in Scotland. And then finally, I'll go through the Scottish Government's consultation and compare it to the draft Children's Rights Scotland bill, and look as well at how it fits with what we know about international good practice. So kind of starting off as to how have we got here. We've got here because we finally got a commitment from the First Minister in the Programme for Government in September of last year that was followed up with a commitment in April where she said that she was going to incorporate the UNCRC into Scots law before the end of the Parliament, which is in 2021. It follows on from a lot of activity that has really stemmed from the fact that children in Scotland are still saying that their rights are out of reach. And that's what we have in the picture here, is something that children and young people drew for us, where they said that they know that they have rights. And they know they have the right to live free of poverty, they know they have the right to be heard and to be listened to, but quite often these rights are just like clouds in the sky. They're not kind of real, they're not something that they can claim that belongs to them. And so this is our chance to bring rights within reach for children and young people across Scotland. And we've got a really solid foundation of work that has got us to this point. So I think we need to start off to talk about what is incorporation, because it seems like a really big, complicated word, and it certainly sounds very legal, but it's really quite a simple process of bringing international human rights into law in Scotland. And because as it stands at the moment, then the UN Convention on the Rights of the Child is just guiding in Scotland. It's something that politicians, that the government needs to think about, but doesn't have to comply with. And so by bringing the UN Convention actually from international law and into Scots law, it will make the rights that it contains for children and young people binding rather than guiding. And it will mean that they can be enforced through the courts. The UN Committee on the Rights of the Child have been very clear about the kind of three things that are important around incorporation. And the first of these is that rights become binding and not just guiding. But it's also that it means that all level of government, so it means national government, but also local government within the NHS, within education, all levels of government need to apply a children's rights-based approach in policy and in practice. And the third thing that the UN Committee have said about incorporation is that it must make sure that rights provide an overarching legal framework through which all other decisions are made. And so this is where it's very important for children and young people that incorporation means that decisions made in environmental issues, in planning issues, in transport, all of these kind of decisions made by government need to take account of the impact that they have on children and young people's rights. So it is a legal measure, incorporation is a legal measure, but it really has consequences for implementation of children's rights in policy and in practice. So these rights that we're talking about incorporating into Scots law, what's actually in a right? It's important to know that within every single human right, then it's very clear that there's a duty bearer, and the duty bearer is the government, and that there's also a rights holder. And in the case of the UN Convention on the Rights of the Child, the rights holder is all children and young people under the age of 18 years old. The way that rights are written also includes a subject of the right. So this is, for example, the views of the child, the right to the highest attainable level of health, the right to an adequate standard of living. But the way that it's written also really sets out what the obligation is on the duty bearer, so what the government needs to do. So every single one of the 42 substantive rights within the UN Convention on the Rights of the Child contain this kind of structure where there is a duty bearer, which is the government, the rights holder, which is children and young people, the subject, and it really sets out the obligation on what the government needs to do to fulfill that right for children and young people. And the UNCRC, aside from containing rights for children and young people, then it's also quite clear that it contains a lot of obligations on governments on what it needs to do to assist parents. There's a good example of this within Article 27 of the UNCRC, which is the right to the adequate standard of living. And it sets out there the obligation on government to actually provide material assistance and support for parents and families to ensure that children have the right to the adequate standard of living upheld. And I think it's important to know that when we're talking about incorporating children's rights into law, because there's always a fear, what does this mean for parents' rights? What about parents? And actually incorporating the UN Convention on the Rights of the Child into Scots law will help to really set out what obligations our government has to parents, to families, to help them support their children. So we've been talking about incorporating the UNCRC for a long time. It came into force in 1992, and since then it has been brought into Scots law on a piecemeal basis. But these conversations have been going on so long that actually many of the children involved in a previous consultation around incorporation are actually now adults and now old enough to vote. So you'll see in front of you some quotes from a consultation with children and young people back in 2011. But now we're here, and 2019, the Scottish Government has launched its consultation. The deadline for the consultation is the 14th of August. And so we've just got about 3 more weeks now to get our consultation responses in place and off to the Scottish Government so that we can let them know what difference we want incorporation to make to the lives of children and young people and what model we think is going to deliver their ambition. Although this conversation has been going on a long time, there's evidence internationally to say that these kind of conversations really help to improve implementation. So we really are at a good point now, the right point to incorporate the UNCRC within the next couple of years. Something that has been done to prepare the ground for UNCRC incorporation is the Children and Young People Scotland Act 2014. And within the Children and Young People Scotland Act, there are duties already on ministers to consider steps that they can take to further the UNCRC, and also to report on the progress that they've made and raise awareness of children and young people's rights. I think importantly, the Children and Young People Act also includes duties on public bodies to report on what they're doing to further the UNCRC. So their first reports are actually due in 2020. And they're going to cover the previous 3 years of what they've been doing to further children and young people's rights. It's important to reflect on this because this means that public bodies have already had, as well as the period of implementation since we first ratified the UNCRC, the past kind of 27 years, this past 3 years, there's been an added focus on public bodies and within public bodies on what taking a rights-based approach means and what the implications are in practice. So we are at a point that we can incorporate, and actually people in Scotland tend to know what that means in terms of taking a rights-based approach in their work. So I said I was going to tell you a bit more about the draft Children's Rights Scotland bill that we put together with a panel of international experts to look at what a real gold standard model of incorporation could look like here in Scotland. You maybe weren't expecting to see a legal bill accompanied by pictures of carrots and pictures of sticks, but I think this is the best way to illustrate really the power of the draft Children's Rights Scotland bill that we have put together. The experts who helped us with this bill have got experience of incorporation in a range of different other countries, having studied how incorporation has come about and how it's had an impact on children and young people's lives. And they've come to us and told us that it's really important not just to secure compatibility with the UNCRC, but also to be very proactive and really encourage governments, encourage decision makers to progressively realise children and young people's rights. So that is why we've put together the carrot and stick model. And the proactive carrot, as we've called it, is the due regard duty. And this is about making sure that duty bearers, that governments take account of children and young people's rights right from the very outset of making a decision. The idea of the due regard duty, or the proactive carrot, is that children and young people's rights aren't violated in the first place, that decisions are informed by the UN Convention on the Rights of the Child, they're informed by the views of children and young people, and that we get things right from the outset. That's not enough on its own, and we know it's not enough on its own, which is why we've also got the reactive stick. So that is a compatibility duty that means that if children's rights are violated, if there is a breach of children and young people's rights, then children and young people can actually go to the courts, and the courts can determine whether an unlawful act has been committed and whether there should be remedy and redress. And so you can find out more about our Draft Children's Scotland Bill using the link that we've got at the bottom of the screen here. But it just shows the importance of balancing measures within a legal bill that actually get things right in the first place, and ones that allow for remedy and redress when things do go wrong. So moving on to what's within the Scottish Government's consultation. For those of you who've seen the consultation paper, you'll see it is split up into 3 different themes. And these themes, the first is legal mechanisms for incorporation. So this is really what should the legal framework be that we use to further children and young people's rights. Within the consultation paper, then the Scottish Government asked about what kind of duty we should include within the Act. And so they suggest that perhaps we should have a duty that says that we should not act incompatibly with the UN Convention on the Rights of the Child. So this really mirrors what we have within the Human Rights Act in Scotland in relation to the European Convention on Human Rights. And it makes it illegal to actually act incompatibly with the convention. This is a really important part of UNCRC incorporation. It's a really important part to make sure that there is remedy and redress through the courts if rights are breached. So we definitely agree that there should be some kind of duty that makes it unlawful to act incompatibly with the UNCRC. And we know from other examples worldwide that this is an absolutely essential part of incorporation. But we do also know from what's been happening in Wales and from the evidence brought to us by our international experts that we should also have a positive duty, so a duty that encourages compliance from the outset and doesn't just rely on the courts if rights are violated. So this is why when Scottish Government are asking about whether there should be an act compatibly duty or a due regard duty, then from the experience that we have, we would actually say that there should be both duties, because it's important to encourage compliance from the outset but also it's important to ensure there's remedy and redress if children and young people's rights are violated. Scottish Government also talk about direct incorporation, or whether there should be a Scottish suite of rights. The usual way of incorporating the UNCRC in the very many countries that have done this so far, Iceland, Sweden, Norway, Spain, Belgium, is to take the full UN Convention word for word and basically enshrine that into domestic law. So this is kind of the copy and paste model. And there are real advantages to the copy and paste model, because it means that it's very clear that the rights that we have in domestic law are exactly the same rights that other children and young people have right across the world. It means that our court, our government, decision makers can draw from the experience of other countries that have incorporated. They can draw from case law, they can draw from the general comments, which is how the UN Committee on the Rights of the Child kind of interpret how the rights should be implemented. It allows, the copy and paste model allows for future-proofing the rights. So as the UN Committee develops more general comments, at the moment, for example, they're looking at digital rights and children and young people's experience of the digital environment, then we can use these general comments to interpret the rights as they are in our domestic law. So there's a real advantage to the copy and paste model, but obviously we need to do this insofar as devolution allows. The challenges of a Scottish suite of rights means that there's real uncertainty. Are the rights that you've created in Scotland the same as the international rights? How will they be actually future-proofed? If more powers are devolved to the Scottish Parliament, you would have to update those rights in order to ensure that they covered the more devolved powers. And so there's real uncertainty as to how a Scottish suite of rights would work, which is why at this stage we're really advocating for the copy and paste model to ensure that rights are future-proofed and to ensure that the bill updates, or the Act updates, as more powers are given to the Scottish Parliament. The next part of the consultation paper is about embedding children's rights into public services, and this is more about the kind of positive duties that I was talking about, the carrot approach to making sure that we get things right in the first place. In Scotland, we do already have the Children and Young People's Scotland Act 2014, and this includes a reporting duty on ministers, a reporting duty on public bodies, and an awareness raising duty. What it doesn't include is mandatory child rights impact assessments. And we know at the moment Scottish Government is very good at doing impact assessments, but we know from international experience that this quite often depends on the will of the government who's in place at that time, and future governments might not be so positive about doing these things. So by making them mandatory, again, it's about future-proofing our bill, our act, and making sure that future governments have to embed a rights-based approach, as well as the current government. It's also possible through a children's rights scheme to make sure that government routinely involves children and young people, that children and young people are involved in parliamentary scrutiny. And so there are all sorts of things that we can do to actually enhance a rights-based approach in Scotland and set it out very clearly in a children's rights scheme to make sure it's not just this government, but all future governments take that approach as well. The final part of the consultation is about embedding compatibility and redress. And as I said, this is an absolutely essential part of incorporation, that children and those representing them are able to challenge public bodies if their rights are breached. So within the consultation paper, they talk about, the Scottish Government talks about, should the UNCRC rights prevail if they're in conflict with domestic legislation? We know, as per the general comments that I spoke about before, that it's really important that that all areas of work, whether it's environment, transport, planning, have to take account of children's rights. So yes, UNCRC rights should prevail, and they should be seen as a lens through which all of the legislation is interpreted. We need to think about how children complain if their rights are violated as well, and this is the area of the consultation that talks about standing. And so we need to make sure that it's not just children who can bring cases to court, because obviously it's very difficult for children and young people to go to court. The first thing that they think about if their rights are breached isn't, oh gosh, I must employ a lawyer and go to court. They might not even know when their rights are breached. So we know, and we've included in our model, the importance of making sure that actually people can take cases on behalf of children and young people. that organisations representing children and young people can actually take cases if they feel there's a repeated breach of children and young people's rights. This way we can make sure that there's a broader access to justice for children and young people, and that no individual child is necessarily having to take a case on their own. I think I'm coming to the end of my time talking about the different themes of incorporation. I'm happy to take more questions on any of these elements of the consultation paper. And what we've also done is put together a number of useful links for you, so that anything that I've said today is actually included in our briefing on the Scottish Government's UNCRC consultation, which is available on our website. And we've also got facilitator briefings to support engagement with children and young people. I'd like to signpost you to the position statement that's come in from the Children and Young People's Commission of Scotland, which is very clear about how incorporation should look in Scotland. All of these are useful resources, but I'm now happy to take any questions that you might have.
Thank you, Juliet. That brings us to the end of the presentation element of the webinar. We can now move on to the Q&A portion. A selection of questions have been pulled from the chat box and will be posed to Juliet now. The first one's from Aileen Wilson. It's, hi, Juliet. What do you think will be the most common myths, fears people will have around incorporation, and how do we answer some of these?
Wow, that's a very good question. There are a number. I think the what about parents' rights is one that I hear quite a lot, and it's most definitely a myth. Incorporating the UN Convention on the Rights of the Child actually provides support for parents. It sets out obligations on government of what they should be doing to support families so they're the best place to grow up. And so I think we need to actually get into the detail and actually read the convention word for word and reassure parents that this is about supporting families and making sure that families have what they need to help children grow up. Another myth is that it will result in lots of litigation and that we'll have children and young people queuing up outside the courts to take cases. We know from international experience that that just does not happen. It doesn't result in more cases of litigation. What it does do is mean that courts start using the convention more as a tool to interpret other legislation. So they start using it and embedding more of a rights-based approach into their decisions, but it's not as a result of individual cases going to the court.
Okay. And tying into that, what are some ways that we can provide clarity to rights holders and duty bearers on incorporation and what incorporation will look like?
I think it's really important to continue the work that the Scottish Government has been doing already around raising awareness and understanding of the UN Convention on the Rights of the Child. So in the Scottish Government's action plan that was published just before Christmas, then they've got a whole stream of work around what they're going to do to raise awareness and understanding of the UNCRC. And we need to do this not just with children and young people and not just with parents, but with local authorities, with people working for health, education. Just have these conversations. Incorporation isn't going to happen right now. We've got until kind of March 2021 until a bill goes through Parliament. So we just need to keep really raising our own understanding, having these kind of conversations. And when incorporation does come into place, make sure that there's very clear guidance as well as to what it means in practice.
And from Tam Bailey, hi Juliet, Scottish Government has previously rejected a due regard duty. Is there any indication of a change of position on this? And does the Scottish Government Advisory Group support due regard? Is there any thought, and has there, that dropped off, sorry.
It is very funny because I was one of the people back in 2012 when Scottish Government were consulting on a due regard duty saying it's not enough, it's not strong enough, we don't like due regard. But actually from the work that's happened in Wales, then we have seen that there's value in due regard. It's so important to see that due regard on its own isn't good enough at all, because it is just a duty to think very hard about something, but combined with a duty to act compatibly, there's a real power in using a due regard duty. I don't know yet what Scottish Government's thinking is on this, and I think they don't know yet what it is, which is why they're kind of asking about it in their consultation. In terms of the Scottish Government Advisory Group, then again, no firm positions have been taken by that group yet. In terms of the Commissioner's expert advisory group facilitated with Together, then we definitely support a due regard duty, but only if it's in partnership with a compatibility duty as well.
Okay. And from Vicky Crichton, the consultation paper seems to suggest that the Scottish Government might favour a model of incorporation by transposing the UNCRC for the Scottish context. Why might this be more appealing to them, and how might they be swayed?
This one it can be slightly confusing, because in the past, when we've talked about transposing, we actually have meant, and within the international understanding of transposing rights, that's actually copy and paste. And so the way that the word transposing is used in the Scottish Government consultation paper does throw up a little bit of confusion by it. So when they say transposing the UNCRC for the Scottish context, they mean kind of rewriting the rights within the UNCRC insofar as they can fit them within the devolution settlement. They might favour this because obviously they're concerned that any bill that's introduced to the Scottish Parliament must be within the competence of the Scottish Parliament. It's absolutely essential. And they're concerned because some of the rights within the UNCRC are out with the current powers of the Scottish Parliament. And so I think they see it as being quite clean to be able to only take elements of rights that are within the devolved settlement and include those in the bill. That's quite problematic in a way that, first of all, it loses the link with the international human rights, and so it creates doubt as to whether the rights that are included within the Scottish suite of rights are the same rights as the rights that are within the UNCRC itself. Secondly, if more powers are devolved to the Scottish Parliament, then obviously the suite of rights would need to be updated to reflect the new powers that have been brought into the devolved settlement. So from the work that we've done so far, it's actually far more simple and far more beneficial to actually copy and paste as much as you can of the UNCRC into the incorporation bill, and just have an overarching duty that says it only relates to the powers that are devolved that are within the settlement of the Scottish Parliament. That way you can make sure that if more powers are devolved, the bill updates. If there's a new general comment from the UN Committee on the Rights of the Child, the rights can be interpreted in light of that general comment. It future-proofs the rights. So copy and paste future-proofs the bill. It makes sure it doesn't need to be updated, and it makes sure that they're seen as international human rights that all children and young people across the world have.
Okay. And from Dinah Atkin, hi Juliet, Scottish legislation has loads of good stuff that is already consistent with the UNCRC. I'm thinking of the additional support for learning legislation in particular, but local authorities consistently fail to provide enough support, and it is very hard to enforce compliance. The result is that children don't access their UNCRC rights. How can we better ensure compliance, short of lengthy, costly litigation, and will there be accountability?
Yep, completely agree. And this is why we think it's important to have a due regard duty as well as the act compatibly duty. Because with a due regard duty, then the government needs to actually set out what it's done to consider children and young people's rights from the outset. So it allows us to challenge decisions, sometimes informally, before they're properly made. It allows us to inform these decisions with the views of children and young people before anything is set into stone. So it's about trying to get things right from the first place, rather than actually having to use the kind of stick of the courts. We've seen that does work to an extent from Wales. Obviously, it's not going to be magic. It's not going to change things overnight. But we've seen as well from other countries, Norway, Finland, Iceland, that there's a real kind of gradual culture change where eventually children and young people's rights are embedded into decision making, and children are seen as rights holders, and we're less likely to have violations of their rights.
Okay, I think we have time for one more. And it's Fiona Colbert. If UNCRC should that be UNC? If UNCRC is incorporated, will the likes of the statutory Scottish Government self-directed support and child protection guidance be reviewed in view of the Supreme Court ruling regarding the impact of the named person legislation in Article 16? So much is incompatible.
I wouldn't be able to kind of comment on the detail of that because it's something that goes beyond what I have the time to talk about in the next minute. But I think it's definitely part of incorporation is making sure that not just all legislation going forward is compatible with the UNCRC, but there is review, there is scrutiny of existing legislation, of existing guidance, and that gradually it is updated, it is brought up to scratch so that everything is compatible and in line with the UNCRC. And that is really important. Sweden has done this. They've actually got a transformation process, they call it, where they're going through all existing legislation and they're bringing it up to scratch. The Scottish Government did a UNCRC audit where they've been looking at implementation of the UNCRC. I think that was completed earlier last year. And so there is work happening on this to make sure that legislation, policy and practice is up to date, but it's going to be an ongoing piece of work.
Okay, sorry, and one more from, let's see. Much of this is about hearts and minds, but has any thought been given to what resources will be required?
A lot of it is about hearts and minds. And I personally haven't kind of started to look at exactly what the financial implications would be, but what I have looked at is what's happened elsewhere. And I think an important thing is to look at other countries and how much it's actually had an impact there. I know from experience of Wales, where there's a local authority that's incorporated the UNCRC, then it hasn't actually cost more money. It's just about how they spend that money. It's about getting a rights-based approach there from the outset. Article 4 of the UN Convention on the Rights of the Child is very clear that you take a rights-based approach as far as available resources allow. And so in terms of resources that are required, it doesn't necessarily need more. It just needs an assessment as to where you spend that money and how you spend that money, and making sure that children's rights are integrated into budget decision making from the outset.
That's great. Thanks for answering those questions. That brings us to the end of the webinar. We'd like to offer our gratitude to Juliet for delivering the presentation and answering everyone's questions. We hope it has provided some insight and takeaways to bring to your own organisations. Before we go, we'd like to draw your attention to some other new pieces of work taking place from the Alliance. The first of these is the Integration Stories, where we're looking to capture innovation and best practice in integration across Scotland. And secondly, our integration network, which we invite you to join, which is aimed at growing to share best practice, learning and shape integration throughout the country. Finally, if you're interested in getting involved or signing up to the integration network, you can get us at these contact details. And then finally, a big thank you to everyone once again who registered for this webinar. We hope that you join us for our next one on the 19th of August. More information to that will be available in the coming days on our website. And don't forget to check out the Alliance Live podcast, which can be found on all major streaming platforms and on our website as well. Thanks for joining.